booming, but you had small groups of individuals at that time around the Civil War who owned large tracts of land. And what they did was they passed it down through generations. And how they did that was through verbal bequest. Now, bequest is a legal word, just which means giving. For those of you who have wills, usually that word is in the will of I bequest my property to whomever. So these verbal bequests, as they were called, were given from landowner, generally the mother and father, to the kids, and et cetera, et cetera. So as the land was passed down verbally, that was not legal in terms of it wasn't recognized by the law. And verbal requests, just so you know, in Arkansas, it's not recognized. You have to have some sort of written instrument in order to pass land, pretty much in all of the 50 states. So how do you do that? Land passes by wills and descent. Again, going back to the original definition of an heir, that will be anybody who's related by blood or marriage that is living at the time of the landowner's death. We are supposed to do, and what I do counsel people today, is to have some sort of estate planning tool that a little later. But how you pass land properly is either through will or through a written instrument. But heir property is created when land passes through descent. There's a bunch of individuals who own the land by blood. So next slide. The legal jargon that you probably hear and that I would like for you to get familiar with is when a person dies without a will. Legally, that is called a person died intestate. All of the deceased property, okay? Property legally falls into two categories. The category of real property. Real property will be land, be homes, anything that is attached to land. And personal property. Personal property is everything else: boats, cars, jewelry, stocks, bonds, dividends, banks, those types of things. All of that property together is called the estate. And the court-appointed administrator is the personal representative of that estate. So what the court will do is in order to clear up heir property, a court will appoint a personal representative who is the administrator of the estate. And that is the person who is designated as the legal representative of that dead person's property, the real and the personal property. And they are the ones who distribute it to the heirs properly. So these are some terms that I want you to be familiar with, because you're going to be hearing these, especially if you have heir property issues in your family. And the last one, TIC, stands for tenants in common. Tenants in common. That's the legal term to describe all of the heirs who jointly own that land. They are all tenants in common. I will explain more about that later. Next slide, please. Okay, so like I said, you have a large number of heirs clouds title. Okay, so when you hear that the title is clouded, basically, fundamentally, all that means is that there's fractional ownership of the land. And why is that a problem? Because you have all of these individuals, brothers, sisters, nephews, nieces, and cousins, who all own this land. In order for the land to be profitable, all of them have to agree. It's rare that all heirs will agree how to use property. If there's timber on it, how to cut the timber down and sell it. Or if it's farm property, how many acreage that we should lease and for how much. It's rare you can get all these individuals to agree. So this creates all sorts of issues and problems that really just stop the land from being economically viable. Next slide, please. All heirs have simultaneous, the one before that. Okay, there are large numbers of heirs. I already covered this slide. The next slide, please, Ms. Lee. Yeah, okay. So when you have a large number of heirs, you have the inability to finance land. Remember, I said that all owners must agree all of the heirs must agree in order for that land to be used. Banks will require that. They will require that all the owners agree to mortgage that property. You can't really lease land, although it does happen a lot. But really, tenants only want to be responsible to one landowner, not to 50, not to 60. But reality is that all of these heirs live all over. Some are in California, Texas. Very rarely do they actually live on the land. There's always generally somebody local, and that person takes the role as a personal administrator, a personal representative. They take on that role, not necessarily legally appointed. So those are the individuals that, okay, next slide. All right, all heirs, right, have the simultaneous right to possess the land, but in reality, only one tenant can occupy the land at once. So again, those are some disadvantages of having multiple owners of land or heir property. Also, you have forced partition sales, and people have it in their mind that you can go to the courts, and if 5 people own the land, the courts will divide the land in 5 equal parts. That, in theory, can happen, but in reality, it never happens. What the court does is the court forces a sale, and then everybody gets their share of what they own in terms of money. And of course, you have tax sales. You have tax sales that result from land that is heir property, and the taxes aren't kept up on it. And that's one of the reasons and one of the ways that African Americans are dispossessed of their land, because no one's paying attention, no one's keeping up with the taxes, and someone comes in, pays the taxes, file the necessary motions, necessary petitions, and now they own your land. Next slide, please. Okay. I covered this. Okay.
I'm sorry, I apologize to you because I know this can be frustrating. I'm admitting people and doing it, and sometimes it's hitting the thing going backwards, so I apologize for that.
Okay. Again, estate planning. Now, these are some solutions to heir property. Is estate planning. And I alluded to this early in the presentation. And what you could have as some instruments are wills. Wills are just a document stating your wish of what you would like to do with your property when you are no longer here, who you would like to own what. And if you want somebody who you think is not responsible or you think will squander all of your life's work, you can dispossess that person, whether it's a irresponsible child or whomever. You can also create land trusts, and I'm going to get into the details of these a little later in the presentation, but these are just the tools that I want you to be aware of that you can do with land. You can provide for the passing of that land through wills and a land trust. You can also put that land into an LLC if it can be economically used in some sort of farming operation, some sort of timbering operation. You can also do a partition in kind, and a partition in kind is what I said rarely happens. It does happen, but it's very special instances where the judge will take the one piece of land and cut it up into 3 pieces or 4 pieces to satisfy everybody's ownership interest in that. Or you can buy out the heir's interest. And an example of that is if there are, for lack of a simple example, if there was just 6 owners and say they're all brothers and sisters, and I, not being part of the family, come in and I buy one of the 6 interests, 1/6 interest, I'll give them $10,000. They give me a quick claim deed. I am now an heir, even though I'm not related by blood. And even though I'm not related by marriage, I bought out the heir's interest. And what I can do is, now that I own an heir's interest, I can petition the court through a lot of legal manipulations and force a sale. I can buy out all the rest of the heirs and I can retain title. And that's another way that African-American landowners lose their land, is through land speculators or people who look for these types of situations. They go out and buy heirs, they hire attorneys, and the attorneys file the necessary paperwork to able to obtain that land. It's really a form of legal taking, is how I explain it. And a survey, of course, you want to get your land surveyed so that you know exactly what you own, and if anybody is trying to encroach upon your lines and take your land through adverse possession. And adverse possession is something that it's not really covered here, but just know that you have to lay eyes on your land if it's rural, if there's nobody living on it, and make sure that there's no one using it, that there's no one doesn't have a deer stand on it, is not using it openly, because if they do that for a certain amount of time, they can actually petition a court after that time is over to take that land and own it for themselves. Next slide, please. Okay, so the agenda wanted to talk about land loss. So this is the epidemic Black rural land loss during the civil rights. So in the quarter century after 1950, over 500,000 African Americans' farms vanished. Okay, they went from 132,000 to 16,000. That's an 88% decline. And according to the U.S. Census, the Black farmers own less than 3 million acres of farmland and comprise of less than 1% of all U.S. farmers. Okay, you want to contrast that to even before 1915 and 1920, where I believe the number was 10 million acres that African American landowners had owned at one particular point. And now it's down to less than 3 million acres, and that number is probably even less when this new census data comes out. Next slide, please. What are the ways that we can protect Black family land? Taxes is one way. Make sure that all taxes are paid up to date. Make sure that the tax commissioner office has a name and current address of all the family members who will be responsible for the taxes. Last will and testament, I covered that. That's a document that expresses your wishes and how you want your property, your land to pass to your heirs. And a title search, these are just things that you can be proactive. You want to make sure that you are active on that and that you know what is going on with your title, if there are any issues with that. And of course, an attorney can help you with that. Next slide, please. These are more ways that you can protect your land. Is you treat it as a business, as you would a business, and you keep track of all your expenses related to the property, any taxes paid, any improvements, any structures to the land that will increase the property's value. Family tree, that's the first thing that I tell clients to do that have heir property issues, is I tell them to construct a family tree, because you have to know who owns what percentage that they own. Each level that you go through, if you have, mom and dad owned land, they had 8 children and they didn't have a will, the land passed to the 8 children. Those 8 children had 16 children among them, and it just keeps on going down. But each generation that you go, from the 8 children down to the 16 grandchildren, they don't own the same interest. The interest that the children own is generally greater than the grandchildren. And you have to construct a family tree so that you actually know who are the heirs and what percentage or what fractional ownership that they own. And it's not the same. And people think that as land is passed down from parent to children to grandchildren, that they all own equally. And they do own equally, but they don't own this equal percentage, or the equal interest in the land are different from each generational line. And a family tree can just go a very long way to assist you with figuring that out. Okay, and clearing the title is again, that family tree is the first step in clearing that title. And what does that mean? Remember, I said that clouded title, it just means many people own the land. So clearing the title is compacting ownership into one person, compacting ownership into an LLC, compacting ownership into a land trust. Those are pretty much the three major options that people go to in order to secure their title and to clear their title for their property. Next slide, please. Okay. Now, the Uniform Partition of Heirs Property Act was an act that I actually advocated for, part of Arkansas Land and Farm Development Corporation, before Arkansas actually passed it as law. It is law in this state and a few other states, several other states. But here are the key highlights and the protections that are codified in that act, okay? And one of them is notice, the co-owner requesting the partition. The co-owner could be another heir, but generally this act was made to protect landowners from outside people, outside land speculators who have money, who can afford to pay an heir their percentage of the land, who can afford to pay for the whole plot of land. For example, in the first example that I gave, where 6 people own land, I'm the land speculator. I give that one of the 6 his or her 1/6 value of that property, and they give me a quitclaim deed. Now I'm an heir. Now I'm a co-owner. So what I can do is, before the Uniform Partition Act was passed, I can just go straight to the courthouse, file some petitions and some other papers and documents, and force everybody to come to the table and be like, okay, it's December 2nd. I want all 140 acres. I'm ready to pay $270,000 right now, buy out everyone. In the past, I could do that, and I could do that pretty easily. But now with the Uniform Partition Act, there are protections that are in there. And one of them is notice. So as a co-owner or co-heir requesting the partition, I must give notice to all the other co-owners. The petitioner co-owner must pass a conspicuous sign on the property. The independent appraisal, the court must order an independent appraisal to determine the property's fair market value as a single parcel. And number 3 is a huge one, the right of first refusal. Any co-owner may buy the interest of the co-owner seeking partition. The co-owner has 45 days or so to exercise his or her right, and if exercised, another 60 days to arrange financing. So what happened is that as an outside person, because generally this is why this law was passed, is not to protect heirs from heirs, but it's to protect non-blood heirs who land speculate and who come into the family, try to take the land from the family. So the right of first refusal goes to the original blood members of the family. So again, using the same example of me becoming an heir by virtue of a transaction, not by blood, I bought out one of the 6. Now I have to give the 5 the right to refuse sale, or the right to sort of, it's a mechanism sort of to block this, to block me from having access to all of that property. So the right of first refusal goes to the blood heirs, and they can refuse my request to buy the whole land. But the only way they can do that is that if one of the 5 or all of the 5 have the money to purchase all of the property. But that is a protection that is built in to the Uniform Partition Act, but it still doesn't solve the financing part, because not a lot, but there's a large percentage of these landowners who really don't have the money to buy out everyone. So this was put in there to protect that. Okay, next slide, please. Family land trust is something that I talked about early. You need 3 things to create a trust. You need a trustee, you need a property, and you need an agreement. So you have a family land trust, a co-owner form that holds title to the property. A trustee, who is like a manager, may or may not be a family member, is designated to make a decision regarding the property. Since the trust holds title to the land and is not divided among heirs, the title remains clear. The responsibility of the trustees are stipulated in that trust agreement, okay? So think of the trust agreement as, or think of the trust as its own entity. So basically you can put land into a trust, appoint a trustee, and that land will be managed according to that agreement. The state really can't interfere with that. No one can really interfere with the trust. And this is actually a very powerful tool if it's right for your situation that I would advise clients to look at, is to probably put their land in a trust for a lot of tax implications and a lot of other benefits that come along with that. So, you need three things for a trust. You need a trustee, you need the property, and you need the beneficiaries. The beneficiaries are the people who benefit from the property. So there will be other heirs. So again, going back to the example of the 6, if I put 140 acres in the trust, the 6 owners will be the beneficiaries of that trust. And if there are farming operations that are happening on that property, the beneficiaries, those 6 owners, all of the proceeds will go according to the agreement, but it will go to the beneficiaries because the purpose of the trust is to benefit the beneficiaries, which in this example would be the heirs or all of the collective landowners of that particular parcel. Next slide, please. Again, the alternative forms of collective land ownership, I said LLCs. Existing family members can form an LLC. The heirs convey the property to the LLC, and the LLC is the owner of the land. So what you do is you just deed the land over to the LLC, and the LLC becomes the owner. Family members should create an operating agreement specifying how many votes each member is entitled to, how profits are to be distributed among the 6, and how the members choose to sell their interests. Of course, there are tax implications, but an attorney can walk you through these steps to see which one of these alternative forms of ownership are best for your situation. That trust may not work for what's going on in your particular situation, and the LLC probably be a better solution. It's just very, very case specific, and a case by case analysis needs to be done by that attorney or by that legal professional to figure out what's best for you. Next slide, please. Okay, that's the end of the presentation. I don't know how much time we have. I wasn't timing myself, but that is my contact information. If you have any questions after this, I do have time to entertain questions now, but I will not be staying for the presentation because I do have to be in court later on. So if anyone has any questions, I'm ready for them.
Thank you, Mr. King.
Yes.
There are a few questions in the chat. The first question is, or the statement, I own Heir property with my brother and sister, and each of our names are listed on the deed. I have a will. My brother and sister do not have a will. My sister just died without a will. How do I manage my Heir property and keep it in the family project since my sister has died?
Okay, that was a lot of facts in that, but I'll take a stab at it. If your sister died without a will and she was an heir and she didn't have a will, then we have to take into account that family tree. We have to see if she was married, how many children that she had, her surviving spouse has an interest, her surviving children has interest. If one of her children passed, their children who are alive now have an interest. So that is by family tree will be the very first place I'll tell you to start. That way you can see who has what. And remember, a will is not effective until you die. A will is just a piece of paper until you die. Then when you die, that's when it lives. That's when it speaks to the court. That's when it speaks to what decisions need to be made with your property. So a will is good for what you want to do later. But if you want to do something now with the land, then those alternative forms of ownership that I went over, those should be, again, viewed to see if they fix your situation.
Okay,
because right now you don't know who really owns what. And when I say you may know who all the heirs are, but you don't know what their percentage of ownership is, and that's very important to figure out. And that first step of that tree will help you do that.
Thank you. We will plan for future workshops on how to build your family tree or complete a family tree.
Yes, ma'am.
The next question is, what does TNFM mean?
On the slide.
Yes.
Let me pull that up right quick and see which one that is. It's a note to myself. And I probably forgot what it meant, but.
If you can't find it, we can follow up with Ms. Flood.
Yeah. Yeah, I forgot. That was a note that I wanted to talk about, but basically the forced partition sales, that's in practice, the only thing that a judge court would do would be to sell the land and not divide it. So a partition is, there's two types of partitions: partition in kind and a sale partition. So a partition in kind, again, is the one I said, when they divide the land up in equal parts to reflect the ownership. If there are 50 owners, 40 acres, that's just not feasible. So what the court does is just they sell. And tax sales, the same thing. TNFM, when I remember, I'll let you know, Sleep. But those are just pretty much notes for myself to talk about. But really, those are just some disadvantages of having heir property, in ways that land speculators can come into the family and take the land from the family.
Okay, thank you. The next question is, I have a hard time finding anyone willing to assist in heir's property. Every attorney I've called has never returned my call. Here in Pine Bluff, what you are speaking of, people taking land through adverse possession, is everyday thing. That's just a comment that.
I can't speak for other attorneys why they won't touch it. Their beliefs that there are a lot of stories as to why that may be the case, but I do the work. This could be expensive, so when you try to get 50 people on the same page, that's time consuming, that's energy spent. So they probably don't feel like they want to undertake. I can't speak for them, but I work with individuals that have heir property issues a lot, all the time. So you can definitely call me. My contact information is at the bottom of this presentation.
And also, I think that's why the incubator project was created, because there's a shortage of attorneys. They may not have the time, maybe. I'm not sure why they wouldn't.
I don't know if it's, they don't have the time or desire. It could be a combination of both. Or, this is sort of a nuanced area of the law, and I'm familiar with it because I've been working in it for over 10 years or so, 12 years maybe. So, a lot of attorneys don't want long, protracted cases, and heir property tends to be that, because you have to find the heirs and you have to petition the court to recognize the heirs. There's just so many steps that go into this, and it's usually delayed. It's usually convoluted by family bickering and family quarrels that really don't have necessarily anything to do with the land, but has everything to do with what you did to me in 5th grade, So you have to navigate those types of issues, and it's difficult. I'm also a certified mediator in Arkansas, so I end up doing a lot of mediating, little attorney work, a lot of mediating in these situations, because families just don't agree. It's true in my family, and it's true in many families. It's just, you have so many different minds and egos and opinions, and it's just hard to get everybody on the same page. That's really the work in heir property for the attorney. That's the real work, is getting everyone to a position to agree.
Yes, sir. Before you leave, do you mind, Karen, could you flip back to his contact information, we have an inquiry
Yes,
about
ma'am.
his contact information.
There it is. Is that you, Miss Lee, talking?
No, this is Candy.
Oh, Candy, I'm sorry, Miss Williams.
Yeah, I'm gonna put it back up on the slide real quick.
Okay, the next question, if an original heir does not honor the right of first refusal and sales outside the family, is there legal recourse for the original heirs? There are several questions to this.
Yes, yeah, because yes, if they don't honor what's codified, what's in that law, then yeah, of course, there are legal remedies to pursue. Whenever anybody breaks the law or don't follow the law, there are things that you can do as an attorney to make sure that the laws are followed, or at least have a review of the situation to see if the laws were followed. You want to get on that soon. You don't want to let a sale go through, if possible. But you want to address that fast and quick.
Thank you. And the second part of the question is, can a trust borrow against the property?
Can a trust borrow against the property?
If you
Yeah,
put your
it can't. It depends on your lender, but yes, it can. They may require some personal guaranteeing in there, and if you know what I'm saying, like they may require you to stand behind the promissory note and not the trust itself. But yes, trusts do that all the time. It's complicated, but it can happen. Trusts they're really, really, really good, depending on your situation. A lot of people just don't know about them, so they're not really utilized. But trusts, they generally operate outside the probate process, and the probate process is what the name of the process is that you have to go through to unclear a clouded title, to make a clouded title what they call marketable title. You have to go through the probate process. Trusts do not, and a couple of other things do not, but trusts are really, really good, and they are being used by others who are in the know. So it's just about information now, and I'm glad that we're having this because this information needs to be out there. And if you want to take this PowerPoint, you can have it. If Ms. Lee wants to distribute it to whomever wants it, that's fine. But the information is on here, and you would know whether you go speak with me or another attorney, you would have a better idea, and you can better be a part of that conversation instead of the attorney dictating to you the conversation. You'll have some knowledge behind you. So that's what I try to do in my daily practice anyways, just arm people with the necessary information that they can have an informed discussion with to know what's next, know what steps it takes next.
I'm sorry, we're getting a few more questions.
Yeah,
what is the length of time someone can squat on your property before they can start attempting to legally take the property?
depends on the character of the land. If it's rural land, I believe it's 7 years. But if other types of land is, I think 15 or so. But it's 7 for rural property, I want to say. 7 years of continuous open and notorious use. What does that mean? That means that that's why I said it's important that you lay eyes on the land, because if somebody has a deer stand, and deer stand's been there for 7 years or so, that is open, you see it, it's notorious, they're not supposed to be there, it's not their land, they're trespassing, and they're doing it all out in the open, and they're doing it for 7 years straight, then they can go ahead and petition the courts for a title to that property and tie you up legally. It has happened, and it's happening right now. It's happening in Dumas as we speak, between 2 neighbors. So that's why you need to get your land surveyed to know where the boundaries are, to know if somebody's actually on it or not.
Okay, I think there was another comment. Here we have less issue with family, but facing large farms with deep pockets and bank ownership.
Say that again.
It say here we have less issue with family, but facing large farms with deep pockets and bank ownership.
Yes, you do have those interests that are out there. Um, that's why it's very important to, if you have heir property, to at least, if you can't get all 15 individuals to agree, at least get a small majority or even a small minority, 4 people, to agree. When you have multiple heirs who are in agreement and who also have the um, ability to pay, to pool their resources together, you can stave off those corporate interests in those deep pockets, because they still have to go by the law. They still have to go through the right of first refusal. They still have all these other steps that they have to take. At the end of the day, it will come down to money, because if the heirs do not have collectively amongst themselves the entire value of the land in dollars to buy it, then that's when the corporations or in the big interests, deep pockets, that's when they are able to take advantage. So it really comes down to financing. The Uniform Partition Act doesn't really address that. It just gives the heirs more time and an extra shield of protection against the corporate interests who have the deep pockets. Just gives them more time to pool their resources together. What they're really banking on is what they've always banked on when it comes to us, and that's just the lack of cooperation, period. That's really how they win. It's not money, it's not the interest, not the deep pockets. It's that these people ain't gonna get together for nothing, and we're gonna take advantage of it. And they do. That's what they think, really. I know. I deal with them.
Yes, sir. We have one more question, and it's how does non-bloodline within family affect heirs?
How does non-bloodline within family affect heirs? If you're not related by blood, if you're not related by marriage, you are not an heir. You can become an heir by buying your way into it, like that example that I gave, when 6 people own land. I come in, offer one of the 6 $10,000. They give me a quick claim deed. I am now your brother. As far as the law is concerned, I'm an heir, and I can then take my position as an heir and do what I need to do to own that land. But the other 5 have resources according to the law on how to block me. But at the end of the day, like I said, it's going to come down to whether or not that 5 can collectively pool their resources to combat my people, my resources, my connections.
Privately, so I apologize for that. Our spouses, you said something about married spouses and I guess stepchildren.
That's a great question. Spouses. Spouses generally have interests that, what they call life interests. And again, I'll have to look at your situation, but spouses generally have an interest for their life in the property, what's called the life estate, if they're married into it. Stepchildren have no interest at all, unless they were legally adopted. The laws for legally adopted children are the same for children related by the blood, right? So if you're adopted, you have all of the rights as a child that was born by blood. So if you were adopted, then you have all of the rights as a child that's born naturally by blood. But stepchildren, no. unless they were adopted legally. So that's why it's important or not to adopt stepchildren, you know, if depending on if you want them to inherit, or if you don't want them to inherit, keep them stepchildren. But they don't, just because you're married, just because I marry you and you have a child and we're married, that child doesn't get to inherit from me unless I adopt him or her. Then they're in my family and they enjoy the same thing my daughter.
Thank you. We've had a few other questions that has been added. One is, I'm sorry, still, what is the cost estimate for establishing a trust?
I don't quote prices because I don't know. It would depend upon your particular situation, but you want to be prepared to spend low end, you know, 3,500, somewhere in there, maybe a little less if it's straightforward, a lot less if you've done the footwork on the front end and gotten everybody to agree, and it's just a matter of just drafting papers. But if it's at the beginning phases where you have to talk to individuals and have to send out notices and that type of thing, then it usually takes a turn. And that's probably why a lot of attorneys don't even bother, because of that time element.
May I ask a question, please?
Yeah.
Okay. Using the example you just gave, if I marry a person who has a child, that child is not mine, and the person, and I die, the person that I married who has that child dies and leave what he inherited to that child. Couldn't that kind of murk up the stepchild situation?
Give me that
Okay,
example.
I'll use that example that you just gave. Just say if you marry somebody who had a child,
Mm-hmm.
then you die, and that person that you married inherit from you, and that person died. Can't that person leave what they inherited from you to their child?
Okay,
That was not yours.
there are a couple of factors involved. That's a great question. Now, if I marry Miss Bell and she has a child and I die, and Miss Bell has, and I didn't adopt Miss Bell's child, that child doesn't inherit from me at all. Now, if I die without a will, my wife, Miss Bell, doesn't inherit from me, really. She doesn't. She has a life estate and some other 1/3 interest in my personal property, I think it is. So she gets some of my personal property, my boat, cars, stocks, bonds, savings, whatever. She gets a third of that, assuming that I have a child. But she estate, my homestead, and my property. Well, I had this married, and in my will, I provided that she has XYZ, then yes, she inherits from me. Or I can use that will for my steps for her child and provide for her child in my will. It was called the laws of intestacy. The child is adopted by me. That's from my estate. So really down to estate planning. Estate planning is taking toll, an account of everything that you have and how do you want these properties, gold. It's very important that that wills are for filthy, and if you own anything, a bank account, have wills. And now a lot of things are electronic. So, I mean, I get real in depth depending upon who the client is. You want to have access to all your electronic words. There's a lot of things to down and do a will, depending on state, what you own and what you.
We know you have other obligations today, and we really appreciate you taking the time to provide us with this information. Do you have any last comments?
No, it's my contact information is there. Please read, or if you have some other questions that is in person, again, or that you may have as a result of this. Doing workshops, please reach out, Ms. Lee. I'm here. Yes, ma'am.
I just want to reiterate, if you do want his presentation, please put your box. I am saying as well being recorded. Say even though he did not remember. So it's he is an attorney. He's given us advice and he's being kind. But also remember that you are talking to an attorney. So at some point, attorney fees are going to have to be considered. I guess that's a nice way of saying that. But we will send the presentation, and within the presentation, it does have his contact information in there. And so just make sure you put it over there in that chat box and get it to us so I can get it to you. And that way you'll have all the information that you need. Did you want to say something? All right. And thank you again very, very much.
You're welcome. You're welcome. And everybody have a good day. I know there's a lot of people on now. Everyone have a good Wednesday, and reach out to me if you need me.
Thank you. You as well.
All right.
Okay, everyone. Next on the agenda is Miss Linda Crenton, and she will be discussing wills and probate. So I think it'll be a good segue and from what Mr. King was talking about. Now we can talk about some of the solutions on resolving some of the heir property issues. Ms. Crenton, if you're ready, we'll open the.
Okay, good morning, everyone. It's discussion. My name is Lee, and I'm the managing attorney in a branch office. Also by King Wong staff, and talk today about probate, easy way, and some estate such as powers of attorneys and related issues like that. Just some brief information about Lone Star Legal Aid. We actually have 13 branch offices in Texas, but our branch office in Texarkana represents people in Hempstead, Little River, Miller County, and Lafayette County in Arkansas. And we work directly with the CALS, the Center for Arkansas Legal Services, which have other offices throughout the state of Arkansas. So today we're not providing legal advice. We're just here to give you some general information that everyone, I think, can benefit from. We see it a lot. And we actually are a nonprofit company, and we represent low-income people for free. So keep that in mind. If any of you need legal services and can't afford that is what we're here for, or you may know someone that's in that area. So, and we'll give our contact information out at the end. But you can definitely go to our website. It is lonestarlegal.org. Actually take applications online now, or it's got all of our phone numbers, and you can call to make an application as well. So we are talking about estate planning, basically, and just to, you know, we are not experts in estate planning. In our practice, we do a lot of different things, including family law and benefits such as disability, Social Security, and this is just one of the topics that we see come across our desk frequently. So I will start off with saying, what is an estate? Many people probably think that they don't have enough property to constitute an estate, but that is not true in most circumstances. Your estate is basically everything that you own in your name, such as your home. If you have any other real estate, land, or business property even, bank accounts, you might have investments or like an IRA, retirement benefits with your job, life insurance policies, as well as, you know, personal belongings such as vehicles and boats and even your household items. So when you start adding it up, especially when you look at death benefits from insurance policies, you will probably find that you have more than you think that you do. So why do estate planning? With estate planning, you can control who receives your assets after your death. You can minimize gift taxes and legal fees that might be imposed upon your heirs when you die. And King is going to discuss a little bit later on, if you become incapacitated, you can still control assets through powers of attorney and naming someone that you can trust, or the same with medical decisions. At least you can decide who would make those decisions for you if you become incapacitated. The purpose of estate planning is to have a say over what happens to you, your loved ones, like if you have a minor child or an incapacitated adult child, as well as your assets. You can name who you would like to be a guardian of your children in your will. And so that's something that everyone really needs to think about. Having an estate plan also helps minimize conflicts between family members after your death. If your wishes are made known, then they don't have to argue about how things should be divided up. It also allows a smooth transition of the assets. So if you don't plan, what's going to happen? The probate court judge will get a big say as to what happens with your assets. People you don't want or don't know may be put in charge. With the will, you can designate who you would like to be the executor of your estate. And if you don't have a will, then as the prior speaker was talking about, there it goes to the intestate plan, which actually, you know, is in the statutes. So not having a plan takes your control out of the situation. There's also loss of privacy, because if you have to go through the courts, or if your family members have to go through the courts, you know, that's public, and, you know, it can get ugly a lot of times, especially when the family members have disputes over the assets. And the assets could end up in limbo. So who needs estate planning? Everyone really needs estate planning. Estate planning is good for older people. It's good for people who may have been diagnosed with an illness before the illness progresses. It's good for younger families and single adults. And it's good for people whether you're wealthy or even if you're low income. And when should you plan? You should plan now. You know, we see so many people that come into our office and, you know, their mother is now incapacitated. She's not able to make decisions, and now they're coming to us, and it makes it a lot more difficult than if the mother would have just planned ahead. So you want to plan ahead before you need it. Again, that goes for everyone. It's just not for older people, but you know, this can happen with younger people as well. As we know, life happens to all of us, and usually when you are not planning on it, and there's no second chances here. So what does an estate plan include? It includes possibly having a will, doing nothing. You know, so many people just don't do anything. You can use joint ownership in assets. You can make gifts to property before you pass away. There's beneficiary transfers where you can actually do a beneficiary deed, and we'll get into these a little bit more. And then a trust is also a possibility, which the prior speaker talked about. And we don't do many trusts in our, but it's definitely something to think about. And so you, an attorney, you have a lot of that. Of attorney, life insurance, and retitling of assets. So what is probate? Probate is the legal a deceased person are handed. It takes place in a local probate court in the county, usually where the deceased person died. It can take some time to get through a quick process. And probate can happen whether there is a will or there's not a will. And one of the things that the court will look at is whether or not there is a will. And if there is a will, is it a valid will? Has it been executed properly? And again, King is going to talk about how to make sure your will is executed properly. The judge will look at what property is in the estate and what debts and taxes need to be paid. And then once all of those debts are paid, who is entitled to receive the remaining property. There is a process to go through with the probate situation. It starts out with a petition filed in the probate court. And if there's a will, then that will be filed as well. An executor will be named. Usually, if there is a will, there's going to be an executor named in the will. If there is no will naming the executor, the family members will usually agree on someone to do it. And if the family cannot agree, then the probate court will decide who has the final say based on law again. The court's going to look at whether or not the will is valid. And if it is, then there's going to be an inventory of all the assets that's involved in the estate, as well as any debts. There will be notice given to the creditors that the probate has begun. And then let's see, what kind of assets are going to go through the probate? So your home, generally the same kind of assets that we talked about, but the problem is that probate can be a little complicated. Again, as we discussed, it takes some time. It can be expensive. Usually you're going to need to get an attorney to do that. I mean, not necessarily, just like all things, you can try to do it yourself, but I think it's definitely something you would want to consult with an attorney about. So there are options that you can take to try to minimize the necessity for probate. And especially in our practice, we see a lot of families that can't afford to go to probate. And unfortunately, like King and I, we're the only attorneys in our firm, and we see a lot of applicants for all kinds of things. We get over 1,000 applications a year. So of course we cannot help everyone, but there's so many small steps you can take to minimize the need for probate. So going back to the process, after the debts are paid, then the executor will get permission from the court to make any distributions of the remaining assets to the beneficiaries. And then that executor makes a final accounting of the estate, and the estate will then be closed. So the assets that go through probate are going to include any assets that are held purely in the individual's name at death, and any property that they own. What assets do not go through probate? So there are several that would not go through probate, and that would include jointly held property with the right of survivorship to the other owner. So if you owned some land, you and your spouse own land together, upon your death, it would go to your spouse. Now, if you are not married, then trying to get that right. You need to include a right of survivorship if it is a non-marital situation, to be sure that that property would go directly to the joint owner. And with the right of survivorship, any jointly owned property like that, the new owner would have complete control of the property upon your death, and therefore it would not go through probate. Life insurance would not go through probate. Generally, you have beneficiaries named in the life insurance policy, so that would not go through probate. Again, it's good in the will, minor children, incapacitated older children, to include a selection of who you would want to be the guardian for that person. Otherwise, a court would look to the state statutes for the order of priority for someone like that. You could make, as far as beneficiaries, you can make your children your beneficiaries. You can make charities a beneficiary. You can make other family members a beneficiary, or non-family members a beneficiary through a will. But if there is no will, then there's no named beneficiaries, no named guardian, no named executor. And that means that the court will look to the priorities established in the statutes as far as who would get your property. Again, we talked about one reason why you wouldn't want to do the probate, in addition to it being just expensive, is the no privacy. Someone could contest it. So again, if you can keep it out of probate, it's going to make it easier on your family members. Again, probate is big business. Attorneys can charge a lot of money, especially, obviously, the more complicated or complex your assets are. or if it is contested, you know, if you feel like your family members might contest something, that it could be even more expensive. So there are steps that you can take to minimize the need for probate if possible. One of the ways is to create a revocable living trust. And again, their speaker talked about that somewhat, but a person sets up a trust, and that usually is going to take an attorney to do so. I would not want someone to set up a trust without an attorney, and to hold his property. While he's alive, he'll be both the trustee and the beneficiary and can do whatever he wants with the property. But when he dies, another designated trustee steps in and distributes to the beneficiaries that are named. And the key feature to this is that it would not have to go through probate. Again, King and I do not do a lot of trusts in our practice. Our clients normally don't have, you know, enough assets to where that is required, and so we don't work with those a lot. But there are a number of other ways to avoid probate that you can do on your own and without an attorney. They're inexpensive, and they are ways to keep specific assets of an estate out of probate. So we talked about the joint ownership of real estate. You know, another way is to give away property before you die. Now, I would not recommend that unless you really don't need the asset any longer and you don't want the asset any longer. Never give away anything, any property that you may want later, even if it's with children. I mean, you never know what can happen with relationships. And so that's really not a good idea unless you know maybe you're getting close to passing and you know who you want to have this property. That would be the only reason that I would consider that. It can also lead to gift tax consequences for the recipient. So that's something to think about as well. The other thing is beneficiary transfers, like with life insurance policies. You name a beneficiary to that, and that way when you die, the beneficiary gets the proceeds directly without having to go through probate. The same is true with retirement plans. And it's very important to be sure and put a contingent beneficiary there in case something were to happen. You know, maybe the beneficiary that you have listed, they may pass away before you do. And so you want to be sure that there is another contingent beneficiary named to avoid it ending up requiring probate. One of the things that we see possibly the most in our practice is someone will pass away and they had a bank account, but no one was on the bank account. It was individually owned by the decedent, and then the bank is not able to release those funds to the heirs. It happens very often, and the heirs usually don't even know how much money is in the account. So they don't know if it's even enough to bother with probate. And there's really an easy way to keep bank accounts out of probate, and that would be to have a joint bank account with a right of survivorship, or designating someone on the account as payable upon death. And so if you have any bank accounts, I would definitely, if you own it individually, I would recommend getting with the bank about designating a person that it's payable to upon death, or making a joint account if you're married, or something like that. Joint account owners are usually best for married couples. It's not as desirable if you are not married, because all account holders will have access to the account and will share in the liability. So if the account goes into an overdraft, you'd be responsible for that. So the best idea is to designate it as a payable on death account. You name a beneficiary, and then when you die, that person gets access to those funds. We've had people that heirs don't have the funds to even pay for their burial, and there's funds in their account, but the heirs can't get to them. So it's really a problem that we see very often. So I would recommend that everybody take that to heart. The other thing is a transfer upon death deed or a beneficiary deed. So let's say if you, this allows you to leave real estate to the person that you name. It's basically a deed to someone that will take effect only upon your death. And during your lifetime, you're able to still manage the asset as you always would. It has no effect until you die. But once you die, it goes straight to the beneficiary. So again, you avoid having to go to probate for that. And the deed must be filed with the county clerk's office where the property is located. And it can be revoked at any time, so long as you put the revocation on file with the county clerk as well. So that's another issue that we see a lot. And, you know, in my experience, people don't take advantage of that as often as they should, because that's a really easy way to make sure that your heir gets that property without having to jump through the hoops of probate. There's also something called a small estate affidavit. So if there's really no debt in the property and you don't have a lot of money, no real estate more than a homestead, then you can sometimes use a small estate affidavit that will also be filed with the probate court. And that's an easier option than probate. We don't do a lot of those, but we have done some. Let's see. So there are ways that are available to avoid probate and can really save your heirs or your beneficiaries a lot of trouble down the road. I would recommend, taking some time to write down kind of your thoughts as far as your objectives on who you would like to get your assets if something should happen to you. Make an inventory of what assets, give it some thought as to what accounts and property you own, as well as what debts you have, and, who you would like to have those assets. And then, you can think about what you can do going forward to make it as easy as possible on the heir should something happen to you to where probate may not be necessary. And of course, getting with an attorney, a professional who handles that kind of thing to help you. Like I say, so many people come in with us after the fact, after someone has passed away, after they find out there's a bank account, but they can't get into it, with just a little bit of forethought, the whole situation could have been avoided. And so you want to get the legal documents prepared that you need to do that, or change the titles, list those beneficiaries. And I think that is what we're here to talk about. King, she is now going to just about, the process of preparing the documents, I think. So King, if you want to take it away.
Good morning, everyone. Thank you for having me. My name is King Wong. I'm a staff attorney with Lone Star Legal Aid, and I work with Lisa. And I'm going to briefly talk to you about preparing to write a will, or preparing what you need to do to prepare to have a will written for you. Anyone can make a will. The requirements are you must be at least 18 years old and you must be of sound mind. Now, what does sound mind mean? Sound mind means you've not been declared by a court or an agency as being incompetent, as you are able to make decisions for yourself without any problems. You know what's going on. And before you sit down and write a will, as Lisa said, make sure you do an inventory of all the property you own and all the debt that you have. And think of people who you want to appoint as a personal representative for you. In the will, this person will be called an executor. This person is someone, if you choose them, should be trustworthy, intelligent, and would act in a way that you would want your property to be distributed to your loved ones. So I say before you name this executor or appoint this executor, you sit down and talk to them and make sure that this is something that this person is willing to do, is willing to act on your behalf after you've passed, to make sure that your instructions are carried out. Another person that you need to consider if you have children is a guardian, who you want to be a guardian for your children. And again, I would sit down with this person and talk and make sure that they're willing to take on a role of being a guardian for children in the event of your untimely passing. There was a mention of trust with the previous speaker and with Lisa. If you have a large estate and you own a lot of property that is worth a lot, you might want to consider putting it in a trust. So you would have to name a person to be a trustee to help manage that property based on your instructions. So those are a few things that you should keep in mind, are the people that you trust that would act in your best interest and would use common sense in making sure that your instructions in your will is carried out. That being said, the components of a will are relatively simple. One, you must identify who you are in your will. Basically, you would name your full name, and your address needs to be put in the will. And you need to clearly state that this is my final will. It revokes any and all prior wills made before this final will. It clearly, that lets the court know this is your last instructions on what you want done with your property, how you want your estate to handle any of your debts. Also, it has to be written. Your will cannot be oral. Arkansas does not recognize oral wills. So make sure that your will is written. It puts into black and white what you want done. It can be typed or it can be handwritten. Arkansas does recognize handwritten wills. Handwritten wills must be in your writing. You cannot have somebody else write it for you. The will must be in your own handwriting. And handwritten wills, they can be contested. They can be easily contested. So if it is contested, then you must have 3 witnesses that are able to clearly identify what your handwriting looks like. And the 3 witnesses, can testify that they know that, personally, that is your handwriting. Of course, you're not gonna be around to to know what's going on, but a handwritten will is subject to some kind of controversy after you're gone. So a typewritten will must be witnessed. Your signature must be witnessed by 2 witnesses, and the 2 witnesses have to be disinterested people. They cannot inherit anything in your will. So if you're going to leave your property to beneficiaries, the beneficiaries cannot witness your signature of the will. So keep that in mind. And the witnesses, their signature has to be notarized by a notary. So after that, you've completed what you want in your will. Remember that you can only sign it, when you're ready to sign it, it must be before 2 disinterested persons. And those witnesses then sign the will before a notary, and that's called a proofing of the will. So as I said, what's in a will? A will, you clearly identify yourself, your residency, and that it's your final will. In your will, you can make specific bequests, and that is you identify what property you want to go to which beneficiary. You could leave something that's a family heirloom, like a piece of jewelry, to your favorite child favorite child or niece, nephew, whoever you want. You can have a list of specific property, and that goes to a list of specific beneficiaries. If you do make a list, make sure you sign and date that list, and that list is attached to your will. Staple it, make sure that it's easily seen that it's one document. Also the same thing, executor, make sure you clearly state who your executor is, and in your will, you can give certain authority. Your will designates what authority the executor has to carry out your instructions on the distribution of your property and settling all your debts. Also, it's probably not a bad idea to have an alternate person to act as an executor of your estate in the event the first person is unable to do so. You can stipulate an alternate person. Again, if you have children, you're going to need to name a guardian for your children in the event you untimely pass away before they're adults. And I always say have an alternate guardian as well, because that person that you originally named, something may happen and they can no longer act as a guardian for your children. And if you have a complex estate, you'll be named who your trustee is. And also in your will, you will designate what authority the trustee has with regards to managing your property that you put in the trust. That being said, after you specifically have a list of property that you want to give to, a specific person or persons, you're going to have leftover property. Leftover property would go into a section called the residue. The best way to think about leftover property is property that you wouldn't think would be valuable. I say like your kitchen appliances, like your pots and pans, those type of things would probably go into your residual. Everyday furniture used, that could be put in your residual part of your will of the property you own. And you can designate who you want to get the residual property. It could be one person, it could be a group of people that you can equally divide up among, and that helps the executor out on what to do with that leftover property. Another thing that you might want to consider are your creditors. Make sure you have instructions for your executor on how to locate what debts you have and who the creditors are, because your estate is going to have to settle those debts. Lisa mentioned the probate process. Part of the probate process is the executor will have to notify all your creditors of your passing, and that if there's any debts to settle, they need to know who to contact to get those debts settled. So that's one thing you need to understand and to give instructions to. Upon your death, your instructions are in your will. You can instruct that you want your debts to be paid first before any distribution of the property. Another thing to consider, will your executor be paid out of the estate for their services? Because it is a lot of work to be an executor or a personal representative for you after your death. Probate, as Lisa said, can take anywhere from 9 months to 2 years. So that person is going to be involved in every business aspect of making sure that your estate distributes your property and closes out any debts that you have with creditors. So make it easy on them. Leave some instructions on what your executor needs to do and where to locate these things. That's pretty much, in general, what a will, what the components of a will are. At the end, after it's been drafted, hopefully by an attorney, you will need to sign it. And so at the time of your signing, read over the will carefully and make sure this is per your wishes, that it's written with what you want. Read it out loud to the witnesses if they're nearby, so that everyone can understand what's in the will. And the witnesses, again, 2 disinterested parties will sign it after they witness your signature. And when they sign it, it ideally should be in front of a notary. Now, right now, COVID-19 has created a big challenge with getting documents signed before a notary, just because everybody's worried about community spread. The governor has relaxed some of the notary requirements for things such as wills. You might be able to find a notary that has already been approved to notarize things electronically. Some people have gotten creative, like we have. We are having a meeting by Zoom. So it could be that your attorney, who's ever prepared the will, has a copy of it with them, and you have it in your possession at your home, and you're discussing, the signing of the will, and your 2 witnesses could also be joined by Zoom, and they're witnessing you sign it. The governor has relaxed some of the rules, but obviously when you do talk to a legal professional about creating the will and signing the will, they will probably have a game plan on how to get it signed before 2 witnesses and notarized. Lisa mentioned powers of attorney, that as a tool for estate planning. A will is not going to be of much use to you if you become incapacitated, meaning you have problems making decisions for yourself and taking care of yourself. So as Lisa said, life happens. Power of attorney takes 2 forms in Arkansas. One is called a general durable power of attorney, and one is called a durable medical power of attorney. These are 2 things that you need to consider if you have been recently diagnosed with an illness, or you perceive in the future that you may become incapacitated. To get a general durable power of attorney, again, you must be at least 18 years old and of sound mind at the time of the creation of the durable power of attorney. Durable power of attorney is basically you appoint someone to act on your behalf when you can no longer make decisions for yourself. This person, again, that you appoint should be someone that you completely trust, who is intelligent and has common sense and would act in your best interest. This person would be responsible for doing things that you could no longer do for yourself, like going to the bank to make a withdrawal, or going to talk to an insurance agent about your insurance policy. When you create this document, would designate this person to with the authority to act on your behalf, and you can decide how much authority you want to give this person to act on your behalf. And you decide when this document goes into effect. It could go into effect immediately if you choose to, and it can go into effect if you decide upon you being found incompetent to handle your own affairs. Then this person would step in. You also can terminate a power of attorney, revoke it at any time you choose. It is just a tool to help you manage your life when you're faced with a situation where you're having problems making decisions on your own. Now, a general durable power of attorney is different from a medical power of attorney. They're two different things. If you appoint somebody to be your power of attorney under a durable power of attorney, they can't make medical decisions for you. So there's a separate tool called the medical power of attorney. And again, you appoint someone who you trust that would act in your best interest and have enough common sense to do the right thing by you. And this person, if they accept it, they have a duty to help you. Medical power of attorney, this person, you decide how much authority you want to give them. You decide when this goes into effect. It can go into effect either immediately, or it can go into effect when your doctor says that you have become incapacitated and a court also finds that you're incapacitated. This person can step in and help you make medical decisions regarding your health. They would have access to your medical records and to talk to your doctor about what is in the best interest of your health. Sometimes if you've got two different people handling, being appointed as a general power of attorney for you and a medical power of attorney for you, you can certainly put into both documents that, they are to work with one another, give the authority to work with one another to ensure that you're taken care of. Again, any power of attorney that you create, whether it is the durable power of attorney and the medical power of attorney, you must be of sound mind at the time of the creation. And at any time at your choosing, you can revoke it. You can also stipulate when the power of attorney ends in the document itself, if you choose to. So that's another tool to help manage your estate. Lisa, do you have anything to add? Did I?
I have to unmute myself. No, I mean, that sounds good to me. I saw a few questions in the chat, which I've tried to maybe kind of write down. And one of them was asking about bank accounts. Let's see, let me just go back and look at this. Is the payable upon death bank service offered by all banks? I don't know the answer to that. I think the best idea would be to just check with your individual bank. I think for the most part, they will have some sort of a option for that. So yes, I would just directly ask that bank and find out. We've had banks where only one person was on the account and they wouldn't let them get the money out. We've had different options on that. Some banks will, if they know it's not very much money, they will let the person go ahead and get it. Sometimes they'll require probate. Sometimes they'll accept a small estate affidavit. So if something like that were to happen, it's important to just communicate directly with the bank and find out what exactly they are going to require, because it's not the same. It changes with what bank you're dealing with. Another question was, are all our children responsible for the debts, I guess, of their deceased parents? And generally, no, and correct me, King, please chime in here, but generally, no, you're not going to be responsible for you're not personally responsible for your parents' debt unless you have personally agreed to be. If the estate is in probate, then the debts must be paid by the executor out of the estate. Those creditors will receive notice, or they're entitled to get notice, and then they'll generally make a claim for those debts. One of them was who pays for the probate fees? And the person who files for the probate is going to have to pay those fees. But the executor can then ask the court to be reimbursed for any costs that they've incurred through the probate.
Yeah, I believe the estate would have to reimburse the executor for costs that person had to pay to put the will into probate. You could stipulate in your will, about reimbursing the executor for any out-of-pocket expenses they incur in overseeing the distribution or the probate process of your will. So.
King, there was one question where, let's see, apparently there's a probate going on in Dallas County, Texas, where the decedent passed away, but they owned land in Arkansas, and whether or not they would be required to probate also in Arkansas. And I do not know the answer to that.
Okay, Mr. King is no longer on the line, but Ms. Brassfield, is there any way you can reply to that?
Hi, my name is Veranda Brassfield. My practice is in Stuttgart, Arkansas. So there are, the statute allows for a few different places that you can probate property. You can probate property where the decedent died, and that's where whoever passed away and owns property wherever they passed away. If there is land in Arkansas, then an Arkansas court can also adjudicate that land and make sure that you can get clear title to that land, and that it will be taken out of the decedent's name and put into whoever the heirs are.
And I think the questioner, they're trying to avoid having to probate in both states, and it's already in probate in Texas. So I would ask that attorney that's handling the probate. Ms. Brassfield, they're trying to minimize their costs in having it in two states.
We may have to follow up with the person that asked that question.
It's a good question, though. It's a good question. Another question was concerning bank accounts, whether or not they can specify to leave it open to be used for something specific. I'm not sure the answer to that. I mean, it depends on, is there a will, or are they giving this property to someone? I generally don't think that's ever really a good idea to leave assets with conditions, and it's not something that I've dealt with. I don't know if anybody else on the call can answer that question.
The only thing I can think of is if you have a bank account, you could put it into the money in a bank account into a trust.
Yeah.
Appoint someone, a trustee, to manage the account. Some people appoint banks as trustees if they have a large number of assets that are valuable. That they own several bank accounts, they can appoint a bank to do so, to help them manage it. So that's an option.
That's a good idea. Good idea. And then there was comments about talking about the virtual notary. And so I don't know if everyone read through the comments or not, but one idea was the banks, you can drive through some of the banks and the teller can notarize it just through the drive-through during the pandemic. And that may work with some banks. Some of our banks here, we've had kind of mixed results with getting things notarized, but that's certainly something to consider. And then there is a Bethany Holloway that is a virtual notary, and they said they've had real good results that she does it via Zoom or FaceTime or Facebook Messenger. So that's another option during this uncertain time of the pandemic. Let's see.
There was one more. Do wills allow non-blood related people to be heirs?
King, you just talked about the will, so.
You can leave property to whoever you want. They could be a relative, a charitable organization, as Lisa pointed out, or a non-relative. If you had, your best friend and you wanted to leave something to your best friend that had sentimental meaning to you, you could choose to do so. A will is basically your last instructions on how you want your property distributed, to who you choose should receive your property. This is something that you control when you're alive and after your death. It's your final wishes. And it done properly, the court will find that it was properly done and will, follow what you say in your will, what you want done. So yes, you can leave property to a non-relative. Long story short.
And could you also explain, when we're talking about estate planning, when does a person's role as the power of attorney expires? Some people may think that because there are a power of attorney, they have access to all of the deceased person's property. So when does it become the executor's role?
Well, the power of attorney ends when the person passes away. The person who created the power of attorney, it ends at their passing. So that's when the will take over in terms of distributing the decedent's property, the person who passed away, their property. So a person who creates a power of attorney, it's done during their lifetime when they are still sound mind. And within that power of attorney, they specify what authority the power of attorney has in related to all aspects of their life. They may give them access to some bank accounts or none of their bank accounts. It just depends on what the person who's creating this power of attorney, how much authority they want to give to the person they appoint to act as their power of attorney, to give the power of attorney. So you still have control. The person who creates the power of attorney has control of how much authority they want to give to the person they appoint to act on their behalf. I hope that makes sense.
Yeah, and I think that's a good question, because we have clients that come in often that someone has passed away and they were the power of attorney while they were living. And so, they have questions about what their responsibilities are at that point, or what their rights are. And, we have to explain that once the decedent is passed away, the power of attorney is no longer valid.
Okay, there's another question. What if your homestead went into probate when your grandfather died? All heirs in the will have died. How, as the only person paying taxes on the homestead, get it out of probate?
Well, if it's in probate, what's going to happen if all the beneficiaries under the will are deceased? Then it's then going to go to the heirs at law, is my understanding. And if it's already in probate, then I think they would look to see, or ask the court to make that determination as to who it goes to. I think just because they're the ones paying the taxes doesn't necessarily mean it's going to go to them. But if it's in probate, I would court to make that determination.
I have just one additional question, Candy. This is from Ms. Brasfield. Is she still on the line? Are you there, Ms. Brasfield?
Yes, ma'am, I'm here.
Okay. This one is kind of sort of similar to that about the taxes, but someone, they sent me the message again. There are 3 people that are in the heirs property. Only one person has been paying taxes. They've been paying the taxes for at least 10 years now. The other 2 people have done absolutely nothing with it, but they've decided that they want to sell the property because they just want to see what money they can make out of it. But they haven't had anything in it other than just knowing that the property was all theirs, but only the one person that doesn't want to sell the property has been paying taxes for 10 years. Does that give that person, I guess that's what they're asking, are they going to be forced to sell since they've been the only one that's been doing anything on the land, with the land, or will they have to go through the court and I guess sell it, or buy it from the other people?
So I will put my information in the chat. That's somebody that I would like to talk to a little more
Great.
about what their options are. I have done a couple of different things, or attempted to do a couple of different things in those types of scenarios. Some of the things that folks do, they try to buy out the other heirs. That's probably the simplest thing, is to try to purchase their interest in the property and come to some sort of agreement. I've had clients that have attempted to quiet title and present their case to the court. So I would just need to chat with that person to see exactly what their scenario is, and I'll put my contact information in the chat.
Okay, great. Thank you so much.
You're welcome.
And I put the contact information for Lone Star Legal Aid in the chat as well.
Thank you so much, Mrs. Crittenden and Ms. Wong. We really appreciate this morning to speak to us about wills and probate. And if anyone need to follow up, you can see their contact information on the screen. It's also in the chat box. And thank you as well, Ms. Bradsfield. She was also one of the participants for the Rural Practice Incubator Project with the Bourne School of Law. So I appreciate you coming on as well this morning. And Ms. Braswell has also put her contact information if you would like to reach out to her. So we are approaching 11 o'clock, and next on the agenda is Mr. Rod Woods. When we first began this morning, we spoke about the Keep It in the Family project and how it's our mission to help landowners to promote healthy forest land. If you are interested in participating in any of the USDA programs, there are steps that you have to go through. We have some deadlines that are approaching that will be discussed at the end of this session, but Mr. Woods will be speaking regarding the first step, and that's obtaining your farm number. You would have to go to the USDA office, the Farm Service Agency, in order to request a farm number. So at this time, I will turn it over to Mr. Rod Woods.
Good morning. As was stated, I'm Rod Woods. I'm with the Jefferson County Farm Service Agency. I'm the County Executive Director there. What we're going to talk to you about this morning is as it pertains to what is necessary to sign up and participate in the various USDA farm programs and subsidy programs and cost share programs. There's a lot of programs available out there to landowners and farmers that can help manage and maintain and make your farming operation, whatever in farming type of information, farming operation you have, add to the profitability of it. First, I want to check and see, can everybody see my screen?
Yes, sir.
Okay.
Yes, sir.
All right. So with that, I'm going to start my presentation here. For those of you who are new to farming or land or just thinking about doing it, this presentation is how to obtain a farm number, which is the basic information needed in order to participate in our programs. I'm trying to for some reason my screen's not advancing here. There we go. Well, there we go. All right. Just to those who are not familiar with us, the Farm Service Agency is a part of the USDA, United States Department of Agriculture, and we're tasked with providing programs and loans to help farmers, ranchers, and agricultural partners. Organizations provide food, fuel, and fiber to the millions of people worldwide. The best thing we can start with, and this is straight out of our handbook, a lot of people have confusion over ownership, as was explained through the previous three presenters. When you come to USDA to establish a farm number, we go by USDA, what we're looking for in order to establish who the owner is. The different scenarios here, the basic thing says the owner is an individual entity who has legal ownership of the farmland, including individuals or entities that are any of the following. And we list those things are listed there. The issue comes in most likely is when we got heir property. Heir property does not fit any one of those criteria for the most part. And that's what comes the problem with getting a farm number if it's heir property. Now, there are ways to still get one it's just, as we like I said earlier, we spent a lot of time, a lot of great information on getting heir property cleared out. That's the problem right there. It has to, you need to really have that stuff straightened out before you come in, because FSA will not straighten it out for you. When you come in, if you can't provide me with some of this documentation listed there on your screen that you are the owner, then we're not allowed to establish you a farm number. So that information we got this morning was extremely good. At least give you, those who have heir property, give you a starting point of where you need to do before you come into the office. Because like I said, without that, there's very little that FSA will do. Now that terminology, that acronym COC, that stands for County Office Committee, will require specific proof of ownership when land ownership is transferred. And you see the list there, a copy of deed. A deed is always the best way, of course, and the easiest way to transfer land and recognize and get you on the way of establishing a farm number. Where it gets tricky with is down there at the very bottom there. It says certification of an heir that may not be able to provide a legal documentation to confirm ownership of the property. That's where, to it in a minute, that we will start looking at documentation such as the affidavit of heirship that can be provided and it can satisfy this requirement to show that the land is owned by the listed people on that affidavit. Said the rest of those bullets there are pretty straightforward. As far as that, it's not, I said, the only time we have real issues with establishing ownership is when you can't provide this documentation that's required. Otherwise, it's pretty straightforward on that. And it seems like it might be sounding like it's pretty broad definitions, but there is no, if you were to go into the FSA office and want to see the requirements for a farm number, there's no handbook or nothing specifically to hand you. This is just what I'm giving to you is just a couple of pages out of a 400 or 500 page book that entails other things. Also, it's just a section out of that handbook that governs what an owner is. How does USDA recognize that what an owner is? Now, the certification we talked about will need to be accompanied with some additional that will help. The more documentation you can bring in to show who the owners are, the better when you're doing a certification. And you see a lot of times there might be somebody whose state tax assessment or bill by itself is not enough. But if done with a combination of other things, then it'll go towards establishing the owner. Of course, a will, an affidavit of ownership or heirship, and then any other document that may exist under state law. If there's any on here that are not from Arkansas, again, one of the reasons why this is written in such broad terms is because ownership law can vary a whole lot from state to state, what is considered and who is considered owners. So USDA can't override state law. All we can do is say, if it's okay in your state, then it's okay with us to accept it, unless there's something in the written regs for USDA or the Farm Bill that says it's not. Then, but we're not going to say establish our or go against what's a state law for what is considered ownership. Now, when providing certification, that will go before the county committee, and they'll determine that it meets the criteria. And what the county committee is there for is to protect USDA's interest. Because if someone turn in a certification, either knowingly or intentionally, that's not true, other heirs can get upset or legally has a right to sue. And as often the case is, they're not going to sue. They're going to sue the person who has the most assets. So they want, the first thing they want to do is sue FSA, because we're the one who decided to use that certification, and it may have been false. So our job as a county committee is to make sure that if it is false, we wanted to make sure we did our due diligence to make sure that, hey, they falsified it to us too. We thought it was true also. And believe it or not, and unfortunately that does happen enough to where we need to be careful when we taking these certifications, because a lot of, I think Mr. King talked about earlier, a lot of these family squabbles come in and play, and one side of the family thinks one side and the other side of the family thinks another. And I've been in several situations where we have two quit claim deeds for the same land. So one of them can't be true. And FSA has to at that time back out and say, look, y'all settle it and come back to us when you have it settled. Those situations get tricky if we've already paid money based on one of those quit claim deeds and find out later that the people we paid were not actually owners. That has happened. That has happened. So that is why the committee is in charge of, when you turn in the affidavit of heirship and any other accompanying documentation, they ought to look over it and make sure that, you know, this is the best information we have. And then if it is, then we'll go ahead and say, okay, that person is determined the owner. If it cannot be made acceptable, if we, whatever, then OGC is called, that's an acronym for the Office of General Counsel, who's basically our attorneys for USDA. We'll turn it over to them, say, y'all look at it, and they'll determine if it's adequate ownership. And if so, then the FSA ownership records may change. Now, that's all just a preliminary just to get you ready to come to FSA. Once you do, again, these obtain a farm number. If you've not worked with us before, you must, register is the same thing as request a farm number. It may be an instance where you already have, the farm may already have a number. If it's a case where you buying it from someone, it may already have a number, and it's just a case where we need to take your name off and put the old person's name off and put the new owner's name on. And the new owner has a deed saying, I bought the land from Rod Woods, and now here's the deed showing that it's in my name. That's pretty easy if it's existing. But if it's a case where the land has never, which happens a lot when we have timberland, it may never have been set up as a farm. And when you have a, needs to be something, well, it has to be something, that deed has to include dimensions. It has to tell me, physically describe that property. Section, township, and range, how many, starting at the point of beginning, going so many feet this northwest, this way. It needs to say stuff like that in order for us to draw it off system. Now GIS system is on the computer. We're not going to physically go out and measure anything out there. That's why it's important that whatever deed you bring in, it has to have some physical dimensions to it, so that we can ever draw it off, so that we know the size and the different properties of that land. it's important also that when you bring that in, that we are able to know those boundaries so that we're not encroaching on other farmers that we've drawn off to also. Now, what you have when you bring in a deed, the dimensions and on that is your official record. Now, we're going to draw it off as best we can, but we're not surveyors. We're not going, like I said earlier, we're not going to go out there and physically draw survey it off or nothing. We're doing it just to establish a baseline, if you will, for your farm. Now, when we get through it, if your deed says it's 39.6, we should come up with pretty close to 39.6 acres. Whatever it should come pretty close. If it doesn't, don't need to get alarmed because nobody's taking your land. It's whatever it is, 39.6. That's the legal acreage, and we can't change it. We're just doing it for our programs, and sometimes it's just the weather of whether we click the mouse just a little bit on this side or that side determines whether or not that is 39.6 or 39.5. And that's how we on that. Going on the farm, once you get a farm number, that allows you to participate with our sister agency, NRCS, and they offer several environmental and conservation practices that can help people improve their land. It's cost share available. I will not go into all that today, but you can contact your local NRCS office, and that NRCS stands for the Natural Resource and Conservation Services. They're in most counties. There's one in every county that there is a FSA presence. There's some exceptions to that rule, but pretty much if there's a FSA office, there's an NRCS office down the hall. And I would encourage you, landowners and farmers, to research and see what they have available, because there's some things out there that could help improve your productivity of the land in which you're trying to do. There's no minimum acreage to register as a farm. I've done people as small as city lots. We've signed them up and given them a farm number on the city lot, and with their intention on partnering with NRCS on cost share and installing a tunnel house and growing vegetables for profit. So we are able to do that if that's what you're interested in. It's always best to make an appointment. Now, and then I'm also talking about pre-pandemic things. Even before then, it is always good to make an appointment, because some things, if you tell us, we can have some of that stuff already there, pulled and ready for you, and it'll cut your visit down a whole lot versus you walk in and we have to go and find records, research, and all that while you wait, and it cuts down on your wait time if you do by appointment. Be prepared to provide your address and social security number, or a EIN number. That's a tax ID number if you are registering with us as a corporation or partnership or trust, different entities that you have applied for a tax ID number. That number, we also be prepared if you have a list on the deed, if there's 10 people on that deed that are said as owners, we're going to need that information on all 10 people on it. So be prepared to have that, provide that with you. We've talked about GIS system, and also if the number is also, once we look at it and see that that farm already had that parcel of land already had a number, then we may not be necessary to change it, and it's just a matter of switching the old person off for the new one. And that's what goes on with that first bullet. Now, the owner is the one who needs to be the one trying to establish a farm number. But if you leasing it from someone, if you want to be considered a producer on that farm, you need to bring us something showing that you have control of that property, normally in the form of a lease. Is required. And that'd be between you and the landowner. And then once you show that you are leasing the land from, then we'll put you on producer of that farm, which gives you certain rights and privileges. But the owner is the main one that, and when we're trying to establish a new farm, is who we need to be dealing with. If you are a operation that's incorporated or an entity, you need to provide proof that you have signature authority and can legally enter into a contract with FSA, USDA. That's very important, because even if you do an LLC or other form of corporation, and it's multiple members in there, somebody has to be in control and be able to sign for that corporation. And if it's a truly incorporated the way it's correctly, that should be spelled out in your articles of incorporation or your board minutes, incorporation, minutes of your board meeting. But you need to have that available when you come in and say, I'm here to sign, I'm Rod Woods LLC, and I'm signing for Rod Woods LLC. Now, if I'm a one-person LLC, that's not, of course, that doesn't make sense. But if I have in my LLC 6 of my kids, then somebody has to be able to sign for the LLC, and I have to stipulate who that should be stipulated in somewhere. And FSA doesn't matter to us who it is. We just need to know legally who it is. Because of the pandemic, and we just started this yesterday, we just got word that some of our offices that were allowing farmers to come in by appointment only, because the pandemic has gotten worse, we've scaled back down, and now that just about every office in Arkansas, you're not allowed to come in to the office. But we're still open. We're conducting business. We just have to be more creative in how we accept and process paperwork. Here in Jefferson County, we got a little box that if you come in and say, look, there's some paper, I call you and I say, look, there's some papers I need for you to sign. They're in the box downstairs. Then you come and you sign them, put them back in the box, and you call me and say, okay, Rod, I've signed them. Then I go downstairs and pick them up. Most offices are doing similar things like that. So I suggest that you always call your local office to make sure what stage they're in. So like I said, some were seeing customers by appointment only, but a lot of them aren't. And as of Tuesday, we lost 26 of them that were open are now closed for office visits. All right, that's a list of the things that you would need. We talked about that earlier. Leases, survey or plat. If it's not in the deed, then if you have a survey, if you had it surveyed or something, then that'll work also. Now, this information here is information to get a farm number, and then this is information you need if you want to earn any payments. Because just because you own a farm doesn't mean you automatically earn payments. And if you do earn payments, you have, whether you own a farm or operate a farm, these are documents that you have to complete in order to participate in USDA programs, and that is with FSA or NRCS. That average adjusted gross income, currently, that is if you earn more than $900,000 in the previous more than 900,000 over the previous 3 years, you're not eligible to receive payment through USDA. you have to certify that to us that you do or you do not. They don't tell us how much you earn. They just tell us that whether it's under 900 or over 900,000. The IRS will tell us that. The 1026 is the conservation plan and identifies lands with highly erodible soils. That's a form that's with FSA and can be in conjunction with NRCS to go up to verify. And the 901 that's if you have a operation that is a legal entity. And that just identifies the members in that entity. This is a website here that will show you, tell us the status of who is open in what county. So I encourage you to visit that if you don't know your county office, local office. And the other one is just information about the coronavirus programs. Real quickly, I want to hit to you about the CFAP2 app. It's called the Coronavirus Program. We're accepting application up to December 11th. You go to that website, it'll give you a lot more information, and you can also even do the application and have it printed and send it to us on that. The CFAP is a real easy program. It's one of the first programs since I've been working that you don't actually have to have a farm number in order to participate. You just have to have an interest in a eligible crop. And those are the three categories of the crops. There's too many crops for me to go over it right now, so that's why I encourage you to go back to that website, and there's a list of the various crops there. But of course, depending on the specialty crops might do a lot for our local small producers who do vegetable crops. Again, those are based on payments of different, it depends on how many dollar sales that you had in the previous year of 2019 will depend on how much money you may be eligible for. And again, just reminding you that the deadline for this application for CFAP is December 11th. And again, CFAP was just a part of the Congress initiated, a large stimulus package, and this was part of it. It's paid to farmers who have suffered production, not necessarily production loss in market, because when the pandemic hit, it closed up a lot of markets, agricultural markets, and affected prices. And a lot of farmers weren't able to sell their product, or if they did sell it, it was at a reduced rate. And this program is designed to compensate them on their loss. Again, in closing, I just want to thank UAPB and how they've put these information sessions together. I think it's outstanding information that we have not had since I've been working with the government, and it's really needed. And I think y'all should be commended for putting together this information, because heir property is a big issue here in Jefferson County. And I just, sometimes I want to help people, but I can't, because they can't get clear title to land, and they should be able to participate in these programs because they funded by taxpayers' money. So you're a taxpayer, you should be able to participate, but you still have to meet our rules. And a lot of people with heir property just can't meet it. So I am really, really appreciative of UAPB doing this and putting this information out, because there's a lot of people that it could benefit from at least knowing where to start getting their heir property straightened out. There's my contact information, also some USDA websites for more information about our programs and our agency. If there's any questions, I'll take them now. If not,
Yes.
thank you.
Yes, sir, Mr. Woods.
Mhm.
Thank you so much for speaking with us today. The first question is, as the operator of that property, do you have any rights to USDA programs?
Yes, you have rights. It depends on the program. There's some programs that require the owner to sign, and then there's some programs that the operator can sign, and it just depends on the program. If you're operating that farm and you're have an interest in the crops that's being grown in that farm, then yes, you have certain rights to participate in our programs. It's just certain programs require the owner to sign. Now, the owner can give the operator a power of attorney to sign for them, and which is very useful if in case of it's a absentee landowner. The person who owns land might be in California, but you just have to be careful that whoever you give power of attorney for, that's somebody that you know and trust and don't mind doing business with you, because that means they have the authority to sign for a lot on that land. And our power of attorneys are only recognizable in FSA. Now that doesn't give somebody power of attorney, they can't go and sign a loan in your name at a bank. It only applies to FSA and NRCS programs for the most part. So, but yes, you do have rights as an operator or producer.
Thank you. The next question, can an estate be an owner?
Yes. So the state is on, as long as they can meet that criteria of those meet that criteria that we talked about earlier. As long as the state can meet all that right there, yes. Yeah, they can be an owner if they can bring the documentation to show that the estate, the land has been put into an estate, and that's the way it's done. Mm-hmm.
The next question, does FSA have an update information on how the changes in the Farm Bill related to heir property landowners will work in Arkansas? The Farm Bill was supposed to make it easier for heir property landowners.
Well, I haven't had any new information. My understanding, there is something they're still working on, but how they made it easier was accepting the affidavit of heirship. That has not always been in that regulation. That is something in direct that came out in the last Farm Bill. We used to there was no affidavit of heirship. So that is what they're saying is has made it easier for you to participate as heirs, heir property. But my understanding, there's some more things that they still haven't unraveled, because it's hard to come up with something that's going to apply for all 50 states because of state laws. And the government has to respect state laws to this, and getting other states to participate or coming up with a policy that can apply to all 50 is proven to be hard to do. But as of right now, I don't have anything other new information about additional things that help people who have heir property. But I do my understanding is they are working on them.
Okay, thank you. The next question, I live in another state and I'm able to meet in person. I think she's not able to meet in person. So can I set up a virtual meeting?
It depends on some county offices are using a Zoom, and some are using Microsoft Teams, which is the preferred USDA method. So that you can do one of those with the local county office. But there's a lot you can do over the phone and email. Most of our forms you can sign and email them to the county office, and the county office can email stuff back and forth to you. We've gotten to where now there's a few things that you have to come and do in person, but a lot of it can be done over the phone nowadays. But a virtual meeting is possible if that county office is comfortable using Microsoft Teams or Zoom. And of course, assuming that individual has access to Microsoft Teams and Zoom, so too. Mm-hmm.
Okay, Mr. Woods, I believe that was the last question for today. Would you like to share any last comments with the group?
No, again, thank you all for inviting me. I always love doing this to help spread and make more access to our small and limited resource farmers to our program. So it's a win-win situation for me. So again, thank you. And my contact information there again, even if you are in another state, I don't mind taking a stab at whatever you got going on. Most time I'll try it, and then my final recommendation would be talk with your local office and let them try to help you resolve your issue or help you out. But I'll be glad to take a stab at it myself and try to help you with your problem or issue. So again, thank you, and you all have a nice day.
Thank you, sir. You as well. Before we close out the session, we could not make this possible without our partners. So I would like to extend the opportunity for a couple of our partners to speak. Mr. Alvin Peer, are you on the line? If he's not available, I'll turn it over to Miss Yvette Brown.
Well, I guess it's not quite afternoon, but it's almost there. Just wanted to take a minute and say hello and thank you to everyone who attended this meeting. I am the outreach coordinator for the agriculture department and also a part of the Keep It in the Family team. And so one thing I would like to mention quickly, because I know we're at or past 11:30, is that I also serve on the Sustainable Forestry and Land Retention Policy Committee. And so one of the things I'd like some feedback on is if you can send me information in relations to what will make it easier for air property landowners. So if you have any ideas on what to make it easier for air property landowners, just in general, what I'm going to do is put my information into the chat box, my email address. If you would just send me an email and I'll take a look at what you have to say. So thank you, Candy, for giving me just a moment here to address everyone, and stay safe all. I guess I'll turn it back over to Candy. Thank you.
Thank you, Yvette. I guess I would like to mention that NRCS, that's who Alvin Peer works for. NRCS will be, their EQIP program, the deadline is December the 18th. So if you're interested in applying for any conservation practices, we ask that you submit your applications by December the 18th, but you have to have a form and track number in before you are even considered for EQIP. Now I will turn it over to Karen Lee so she can make a few announcements.
Okay, we want to really thank everyone for your participation and being in here with us. This was a lot of information in a short amount of time, but we will do another workshop of this capacity again. Just wanted to announce a couple of meetings that we have right now on the calendar. We do have an EQIP meeting that will be on December the 16th. This one is just going to cover cattle production, so we can talk about the practices that are available for cattle producers. With the EQIP deadline being December the 18th, we're trying to make sure that we get everybody and get as much information out there as possible, because this will take care of the 2021 fiscal year. So if you miss this deadline, you will not be able to apply again. You will be able to apply, but you won't be ranked again until next year, be considered for the ranking. So if you miss this deadline, you're going to miss out for next year. Also on January the 11th, we will have a hemp production workshop. We'll have someone from the plant board, an attorney that's working with hemp will be on there. We'll have someone that has something to do with disease management. We'll have someone also that will be talking about processors and different processing facilities and what they are expecting, because we've had farmers to go into this business and then produce something that was not marketable. So we're trying to tackle some of these things before individuals get to their planting season this next April, May time. So those are the two meetings that we have on record right now. We will obviously be doing more, but those are the two we wanted to put out there. December the 16th, EQIP for cattle production, and January the 11th for the hemp production. I want to thank again everyone that was on, especially to Attorney King, to the Lone Star Law Firm. We want to thank Ms. Brasfield. I'm sorry, Ms. Brasfield. We want to thank Mr. Woods with FSA, definitely a vet for all that she does with Arkansas Department of Agriculture. We want to thank Candy again for her invaluable leadership and her outreach efforts. These meetings are done with the hopes to empower people to be sustainable and to reverse some effects that have happened. But if you don't put this, it's all for nothing. So we are really homing in on what you learn, put it into practice. We have people here that actually go out and help you put these things into practice, and it's at no extra charge. There are some things that are going to cost, but the benefits, you know, we're talking about generational wealth now and generational opportunity, because land is wealth. What you do with the land is wealth. So knowledge is power, but it is futile if you don't apply it. So that's why we do what we do. We thank everyone for attending, and that's it. I'm here at University of Arkansas at Pine Bluff. Dr. English is here. Stephan Walker is here. Lavelle Foote is here. Damian White is here. Then we have people that are outreach extension associates with Charlie Williams. We have Joe Friend. We have Candy. We go out, so we're not limited to the campus. Even with a lot of places still, you know, because of the virus and stuff like that, we still go out. We maintain our social distances. We have our masks. We have masks and gloves if need be. But what we're trying to say is we are here to help and willing to help. We just need people to do their part. And that means that you're going to have to do some work as well. Everything is not going to be handed to you, but we're handing you as much as possible. It becomes your responsibility to be a good steward of the knowledge and the tools that are available. So we thank everyone for that.
Okay, thank you all. We are planning another meeting for December the 8th. It'll be an evening meeting, and we will send that flyer out by email here shortly. But again, we would like to thank you all for participating, and please reach out to us if you are interested in applying for EQIP. Just give us a call and we will walk you through the process and make sure your documents are inside the USDA office before December the 18th. With that, I will close, and I hope you all stay safe, and please feel free to contact us at your convenience. Thank you.